Hello everyone, and welcome to our next substantive topic, which is non-fatal offences against the person. Please, if you find this video useful, like and subscribe. But we're moving on first to the question of, look at this picture. Has a criminal offence taken place? What do you think? Now, if you were to say that it looks like there's an assault that's taken place here, or indeed a battery, you'd be correct to perhaps think that. If, however, you were also thinking, linking to our previous topic of mens rea, that this looks purely accidental during the marathon, the race, he's reaching out his hand, perhaps not realising that the lady is in close proximity next to him, then you might well be correct as well. And of course, without mens rea, we know that there is no crime. So this image is really one for you to interpret whether or not he's cheating or not. Now, the non-fatal offences we're going to examine today, we're going to look at in terms of seriousness as well. So starting with the least serious would be assault. Assault is a common law offence, so you won't find the offence itself outlined in statute, but you will find the sentencing, how it's charged, or how the defendant is charged, found under section 39 of the Criminal Justice Act 1988. So how it's charged is under a statute, but in fact the offence itself is common law. The same can be said of battery, so it's a common law offence and charged under the same statute. And then as we increase in our levels of seriousness, we then reach section 47 of a statute called the Offences against the Person Act 1861. And under section 47 of that statute, you will find actual bodily harm. So this is the point at which we can say that with assault and battery, there is no, the victim suffers no injury. There's no resulting injury. When we touch on section 47, that is when there is an injury, as we're going to discover, actual bodily harm, and then there's still two more after that. So section 20, more serious than section 47 still, is called malicious wounding, or GBH, and you'll remember that GBH means grievous bodily harm, in plain English, serious harm. And right at the top, the most serious of all, is section 18. Again, the same statute we've been talking about, Offences Against the Person Act 1861, and this deals with wounding or causing GBH with intent. Now, what makes this one the most serious, you may well have spotted, is the mens rea. Whilst section 20, section 47, battery and assault can be committed intentionally or recklessly by the defendant, section 18 can only be committed intentionally. So section 18 is a specific intent offence, therefore the most serious, carrying a discretionary life sentence, and section 20, section 47, battery and assault are all examples of basic intent offences, because they can not only be committed intentionally but also recklessly. And we know, don't we, from our previous topic of mens rea, our pyramid of seriousness of culpability, recklessness is just below intention, so therefore that's why these offences are categorised less seriously than 18. So assault and battery are often referred to as common assault. Now, if you watch the news on television or read the newspaper about any crime stories that are reported, you may often find that they're just referred to as common assault. We are actually, as the law does, going to differentiate between what assault and battery is. But I think it's worthwhile noting that that's how sometimes they're also referred to. So if we start with assault, the common law offence, you won't find the offence outlined in a statute. The actus reus, the guilty act, the physical element of a crime, you may remember, is the defendant causes the victim to apprehend immediate fear of unlawful violence. The mens rea, therefore, is the defendant intentionally or recklessly causes the victim to apprehend immediate fear of unlawful violence. Now, this is an offence that can be sentenced up to 6 months in prison, and or a fine may be given of up to £5,000. So this is a offence that typically would be dealt with in the magistrate's court. Now, in terms of key cases, just as we move forward, one note to make. In terms of, and I'm talking about AQA law here, the A level, in terms of what's expected of you, you would be expected to identify the offence. If we're talking about a 30 marks question, problem scenario, if it's a 10 marks question, problem scenario, of course it will tell you what the offence is, but you are therefore going to need to learn the actus reus and mens rea, and the wording, being quite accurate there, to outline it in your answer. But also, you are expected, when you give the actus reus of each offence, to give a corresponding supporting case. And likewise for the mens rea of whichever offence you're talking about here, again, a corresponding case. So that's the minimum. That's the minimum if you want to do well. There should be a case for the actus reus and a case for the mens rea. Now, there will be instances where aspects in the problem scenario will perhaps lead you to want to raise other cases. And that is obviously the difference between, getting a good grade or indeed a high grade. So the first case that I perhaps recommend you use for the actus reus of assault is called Constanza. In Constanza, the defendant sent over 800 threatening letters to the victim over a period of 20 months. The ratio decidendi, the law that came out of this case, is that words can amount to an assault. So words, whether they be verbal or written or in an email or a text message or whatever, if indeed they are threatening, can amount to an assault. Now, I have seen some people use the case of Ireland as their main case for the actus reus. That is perfectly fine as well for assault. In the case of Ireland, the facts were, interestingly, the defendant made silent phone calls to 3 women. And I say interestingly because the ratio of this case did decide that silence can amount to an assault, if of course the victim perceives that to be threatening. So again, you might very well want to look out in your problem scenario in an exam whether or not that is something the examiner has put into it, and then you can discuss it further with this case. And remember, by discussing your cases and the relevance of any particular precedents, particularly if they are, very similar to the problem scenario in an exam question, will result in more marks for you. And certainly your discussion is your AO3 marks of how you analyse the cases. Now, someone you know discovers that you have been having an affair with their partner. You receive a text message from them saying they know it's you and they are going to beat you up before the week is over. Will this be an assault? So this is really a question of immediacy. If you recall the actus reus of assault we outlined earlier, what does the word immediate mean? Now, I think everyone would generally accept that a text message being received threatening to beat you up would indeed be threatening and an assault. Would your answer be different if the person was out of the country? So in the one instance, we've got a scenario where perhaps you feel the person is close by, and in another scenario here, you've got a situation where they aren't close by, they're in another country, it's going to take hours, perhaps more than a day for them to potentially reach you. Would that make a difference? So there is a case law that helps us here. Now, the key case we have is Smith and Chief Superintendent of Woking Police Station. The facts: the defendant broke into the victim's garden at night and stared at her through her bedroom window. So from her perception, clearly here is a stranger staring through a bedroom window, and she was fearful of what violence may be put upon her next. Is she going to be assaulted, for example? Even though there was a window between her and the defendant, so clearly he wasn't going to instantaneously be able to reach her. he was outside of that building. But the law that came out of this is that immediate does not mean instantaneous, but imminent. And so I think clearly this is the right and fair decision in the case, because if it was held to be instantaneous, the fact here that this man, was outside of the building staring through the window at her, he wouldn't have immediately been able to have got into her property, and therefore we could have had a situation where the defendant is not found guilty, and that would be wrong. That wouldn't be justice. He's clearly at fault here. So if we relate that back to the scenario we just spoke about, if someone sends you a threatening text message that they're going to beat you up, even if that text message were to say, at the end of the day or at the end of the week, then that would be very perceptibly, in the eyes of the court and the law, immediate threat. That would be an imminent threat. If the person is outside of the country, well, it's a debatable point, but I think probably the same could be said. Now, if someone tells you they're going to kill you before laughing and saying they're only joking, are they liable for an assault? Words clearly have power, whether written or verbal. And I think it's worth noting that perhaps it would depend who this someone is in this instance. If this someone, for instance, were a stranger, then clearly that would be, I think you would agree, threatening. Even if they said they're only joking, I think you would be fearful of perhaps what potential violence may come next, because this person seems very sort of unstable, not someone you want to be around. If that someone, however, were a friend and a close friend, then you very well may not experience or apprehend any fear of unlawful violence, because they're joking, they're just messing around. So I think how these words are perceived by the victim matter. So they do matter. So do look out for that in an exam situation. Even perhaps a situation, I'm just thinking, where in the problem scenario, a victim is threatened, perhaps by strangers I described. Maybe they're not, even afraid. They just laugh it off. There's no indication. So if there's no apprehension of immediate fear of violence, then there is no assault, essentially what I'm saying. So it's worth looking out and making that point. It's about the reaction, isn't it, of the victim. So a key case here, and something just to look out for, again, in your scenario, the whole point about, someone saying, oh, I'm only joking. Well, words can have the effect that they annul, that they prevent or remove that threat of assault. So in this case, a very old case, defendant put his hand on his sword and said, if it wasn't for a size time, I would not take such language from you. Now, as far as I'm aware, a size time, this being the 1600s here in the UK, would effectively be local justices, local judges visiting, your town or whatever. Effectively, what we have today is magistrates, don't we, with local justice. So if it weren't for the fact that law practitioners or judges are visiting, I would, and the threat, I suppose, holding a sword is, I would kill you. So here, words can prevent an assault. So look out for that in an exam situation where the defendant tries to suddenly retract that threat. Now, whether or not they're successful enough is a question for the court. I do think there is another case. I haven't put it into this presentation, but from memory, I think the case is called Light, Light, Light. You may need to just search for it in relation to assault, and it does show the opposite. So all I would say is, have a discussion in your exam answer if this arises, that it's possible that the threat could be removed, but it's again about the perception of that threat by the victim. In the news very quickly, Stephen Licorice, 47, was found intoxicated by 2 police officers. This is back in January 2021. This was obviously at the height of COVID-19. Now, as the officers attempted to calm the man, he spat on the stab vest of one of the police officers. The police officer, unfortunately, a few days later developed COVID-19. Now, interesting that, if someone spits on somebody, there is going to be an assault there, because you're going to apprehend immediate fear of unlawful violence. If someone spits at you, someone sort of makes that lunging gesture at you. Interestingly as well is if the spit were to hit the victim, that then would make it a battery. So we'll talk about a battery in a minute, but you can have a situation like here where you've got assault and battery, or collectively reported as common assault. Anyway, it couldn't be proved, matter of causation in fact, that the defendant, Stephen Licorice, had caused the officer to catch COVID-19. But nonetheless, he was charged for a lesser offence, and he was sentenced to 10 weeks in prison. So there's a news article there. So one would imagine it was, assault battery that he was charged with, which we know up to 6 months imprisonment and or a fine up to £5,000. It looks like here that's the case. Had it been proven with the evidence that he had caused the officer to be infected with COVID-19, then we're talking about an injury. We're talking about again, very serious it was there. It could be certainly actual bodily harm at the least. There may be an argument for worse, because biological disease can be a non-fatal offence that's relevant to this topic. So it doesn't just have to be physical harm. We're going to learn shortly that it can in fact be psychiatric or psychological harm, and biological disease again can be. But here's just a news story showing, I think, an example of assault and battery. Now, some scenarios for you to look at for whether an assault has taken place. So first one we have here, I'll read these out, and then of course you'll feel free, if you'd like, to pause the video and have a go yourself with what you know. While home alone in the evening, Jill receives a call on her mobile phone. However, when she answers it, she realizes it's an obscene call from an unknown person. Angry, Jill shouts at the caller, who says to her, "I'm going to kill you." And I've put here, also, would it matter if it were a silent phone call? So, what do we know about the actus reus and mens rea so far of assault? We know that the person that's making the call here, that would be the defendant. So calling Jill, the defendant would have to cause Jill to apprehend immediate fear of unlawful violence. And I think it's fair to say that when he says, "I'm going to kill you," the case of Constanza that we talked about earlier, that words can amount to an assault, would clearly be our supporting case here. If it were a silent phone call, then we would use the case of Ireland that we also discussed. In terms of mens rea then, it is, if you recall, as a basic intent offence, the defendant must intentionally or recklessly cause, in this case Jill, to apprehend immediate fear of unlawful violence. So ask yourself, are these phone calls being done intentionally or recklessly? Now, link back to our previous substantive topic of mens rea. Remember, of course, that intention being more serious than recklessness. Intention is when the defendant, desires the prohibited outcome, that consequence, that crime. They desire it. Recklessness is where the defendant realizes the risk but goes ahead anyway. And I think it's clear to say here that having made that phone call and saying what saying what he did, this looks like a case of intention. So we have proven assault. Now, while babysitting for a neighbour one night, Laurie looks out the window and notices an unknown person to her, Michael, in a white mask and boiler suit, staring at her from outside. Again, what do we know about assault? So we say about assault, the actus reus is the defendant causes the victim to apprehend immediate fear of unlawful violence. This should make us perhaps recount a similar case that we just talked about, the Smith and superintendent of Woking police station. That man, the defendant, who was staring at the victim from outside through her bedroom window outside in the garden of hers. So here's a situation, we've got someone staring at her from outside. So I would say the actus reus is fulfilled here when he's staring at her from outside. You could use the case of Constanza or Ireland as we described, but a better answer would use that Smith superintendent of Woking police station case, and make the point that immediate doesn't mean instantaneous, it means imminent. And from Laurie's point of view, there is an imminent threat. She is fearful of what violence might, befall her next by this Michael that she doesn't know. Now, mens rea, same as before. I'm just going to cut through it and say, is this intentionally or recklessly? On face value, I think you would probably say intention, wouldn't you? But if we were to change the context of this scenario, and perhaps it would, someone playing a joke or something like that, then you might well say they're being reckless, aren't they? They realise the risk that it might frighten someone, but they go ahead with it anyway. So for this, I think it looks like intention. So let's click there, and you can see that's the case we talked about. Now we've got Mick is in a pub watching his football team when a group of opposition supporters sit near him and begin shouting at him. As Mick turns to leave with their back to them, one of the group suddenly throws their drink at Mick, but misses. Now this is something in an exam problem scenario that has cropped up a few times, and you've got to be careful when you look at it. You will often see that there's a situation where in this scenario they present the victim's back being, to the defendant when they do their threatening act or whatever. Now, the key word we talked about in the actus reus for assault is apprehend immediate fear of unlawful violence. And you can't apprehend, you can't perceive threatening violence unless you see it or hear it or whatever it might be. And in this case, because his back's to them, Mick, he doesn't know something's been thrown at him. Now, if it, passes over his shoulder and then he sees it and he sort of flinches, perhaps there's an argument to be made. But I think the point that they want you to discuss is, if he can't perceive it, if he can't apprehend it, there may well not be an assault here. Interestingly, though, if the drink were to touch Mick in any way, I think we're going to talk about that later, then certainly there could be a battery. So, is this done, again, actus reus, it's up to you which case you want to use. Constanza, Ireland, Smith, just broadly one case to support. Is this done intentionally or recklessly by the group of supporters? Well, it looks like they're being abusive and such. It looks like this is intentionally being thrown at him. It says throws their drink at Mick. I think throws their drink at Mick suggests that he is their target. This is done intentionally. Okay, so let's move on. So we're moving on to battery. Again, it's a common law offence. The actus reus, though, is that the defendant applies unlawful force to the victim, as you can see there in that image. Now, the mens rea is, as again, it's a basic intent offence. The defendant intentionally or recklessly applies unlawful force to the victim. This is an offence which, as assault is, up to 6 months imprisonment and or up to a fine of £5,000. So this will be again dealt with in the magistrate's court. How hard do I have to touch you to commit a battery? Is it, as little as me prodding my finger at you? Do I have to the force of a punch? What sort of, how hard must it be? Now, I think a case that helps us with this, and so therefore this is the case that we would like to use to support the actus reus of battery that we just outlined, is Collins and Wilcock. The facts: a policewoman took hold of a woman's arm to stop her walking off, which in the context of that situation, he was not allowed to do. That was against the law. So she wasn't under arrest or anything like that. The ratio, the law coming out from the case, is that apparently the slightest touching can amount to a battery. So to answer that earlier question, it could just be contact of any form, frankly. Okay. So I think another scenario, if there were, say, in the workplace, let's say there's an issue of like sexual harassment and so forth. I don't want to overlap it too much with other topics, but let's say that a person, your boss, puts their hand on your knee or on your shoulder, okay, and I think particularly I'm thinking the context, if it's perhaps a female employee, then that could certainly amount to be a battery, just the slightest touching, because there is an absence of, consent. Now, a key case here, which you may also want to use, and I think look out for this, DPP and K, Director of Public Prosecutions, DPP stands for, and the facts of this are that a 15-year-old schoolboy hid sulfuric acid, which I believe he stole from his school science lesson, inside a hand dryer in school. Before he could collect it, another boy used the hand dryer and was burned. Now, why this case is useful for battery in terms of the law is that the ratio is a battery can be from an indirect act. In other words, the defendant does not have to directly touch the victim themselves. So this opens up the possibility, doesn't it, of situations where perhaps for argument's sake, the defendant were to set up a booby trap, some sort of trap for somebody, or maybe there's someone doing a practical joke where there's a bucket of water above a door that when the person opens the door, it triggers the fact that the water is going to soak them. So either way, a battery can be through an indirect act. I think there was another case, just an example off the top of my head, not on this slide or presentation, but I think it was a case of Martin. You're welcome to look that up. And I think, if memory serves, Martin was where it was some sort of theatre or auditorium, and somebody, I think, shouted fire, and they put a metal bar on the outside of the exit doors so that people who were streaming to try and escape from that room couldn't, and then people ended up getting trampled, and batteries took place there. So yeah, can be through an indirect act, so look out for that in an exam situation. Now, the mens rea for assault and battery, so we're going to deal with both here, assault and battery. I think the case we want to use here is Majewski. So this is the case of Majewski, and the defendant, high on drugs, went to the pub for a drink. He got into a fight with two men, the landlord, and attacked the arresting police officer. The ratio, therefore, is just backing up what we've outlined so far about the mens rea of assault battery. It can be committed, the offences, intentionally or recklessly. Now, remember the word subjective from our previous topic of mens rea. It's a subjective test, so the defendant is going to be liable or guilty in terms of the mens rea, and if we're talking about recklessness, say, if they realised the risk themselves but went ahead anyway. So a battery can be committed as well, and we've seen this before, through what is known as a continuing act. This is the contemporaneity rule, the coincidence of actus reus and mens rea occurring at the same time. You will remember, of course, that formula we did. Actus reus plus mens rea equals a crime. The exception, of course, being strict liability. That's another topic. But again, look out for this in an exam situation. It may be something that they present because we saw it, didn't we, in this case before. Do you remember a case where a battery took place showing this? And the case you should be thinking of is Fagan, the case in which the police officer asked the defendant in his car to pull over. Defendant accidentally parked his car on top of the police officer's foot. The police officer screamed out in pain, told him to get off of his foot, and then, realizing his mistake, the defendant said quite calmly, "You can wait." So we saw, if you recall in the previous topic, that timeline where the guilty act, the actus reus of battery, that unlawful, he applied the unlawful force onto the police officer's foot. The battery actus reus took place first when you drove on top of it, but it was an accident, no mens rea. And then, of course, realising the mistake and refusing to move is where he's showing intention, isn't he, to cause that battery. And therefore, in the space of minutes, we have a crime. Okay? How can a battery take place without an assault? Now, we've sort of touched on this in a roundabout way, but the answer being when someone attacks you from behind and you're unaware. So we spoke a moment ago about that scenario for assault where somebody turns their back and the person behind them throws their drink at them but sort of misses. There's no apprehension perhaps of immediate fear of unlawful violence. If someone sneaks up on someone and they don't know they're there, they're not apprehending anything. If the person were to then go behind them, like boo or something like that, or whatever, then that would be an assault. That would be words. Again, whether a threat is perceived. If it's a friend playing a practical joke, then there's a debate to be had there. But if it's a stranger that does it to you, then clearly that would be the case. But as I said, if someone sneaks up behind you and grabs you by the shoulders, then that would be a battery. So we've got some problem scenario activities here if you'd like to have a go yourself. As before, you know what to do. You can pause the video and work your way through them. I'm going to talk through them now. So Amy is on a train making her way to college. At the next stop, as more passengers begin to board and the train fills up, one passenger, Fleur, moves past Amy and bumps into her. Now, has Fleur, this passenger who bumps into Amy, committed a battery? Now, I think actually the point I raised this one is that probably the answer is no. The Queen's Bench Court ruled in a case we haven't discussed yet, I know, Wilson and Pringle, that everyday inevitable jostling, as they labelled it, is not a crime. So I think, clearly, if every little, for example, unwanted contact were to result in court action, it would lead to the floodgate of claims being opened up, and the court, frankly, wouldn't have the time to be able to deal with all of these. They only really want to deal what is, conduct serious enough as to amount to a crime. So if you're in college, for example, you're walking down a corridor, someone, bumps into you with their bag, perhaps you could say there's no mens rea there. They didn't realise it. But even if someone, does sort of push past you, it's not, in all likelihood, going to amount to a crime. So that's a useful case, I think, just to note down. Sarah is out walking in her local park during winter when she walks past some teenagers throwing snowballs at one another. One teenager misses with their throw and it hits Sarah square in the face. Now, firstly, what do we know about battery? Let's remind ourselves. The actus reus is the defendant applies unlawful force to the victim. the victim here being Sarah. Now, the unlawful force is clearly that snowball that hits her in the face. The mens rea we have is the defendant intentionally or recklessly applies unlawful force to the victim, Sarah here. Now, it looks like with the teenagers throwing snowballs at one another, one could probably assume they are demonstrating, or the person who throws it, the teenager that throws that one that hurt Sarah, he's throwing it with intent to hit someone else. And so you may well be ahead of me on this if you think back to our previous topic of mens rea. Just because he misses the teenager and it hits this innocent sort of bystander, Sarah, is not going to prevent a battery from taking place, because his mens rea has transferred to Sarah this new unintended victim, and therefore this is the rule of transferred malice. And so I would expect in your answer in the exam, having given a case for actus reus of battery and the same for mens rea, you would be expected to deal with transferred malice, to explain this doesn't prevent the offence from occurring, and to use the case of, I think we used Latimer, didn't we? Remember Latimer, the sort of defendant has an argument in the pub, an old case, takes his belt off to strike the man, does strike the man, but the belt bounces off of the man and hits a nearby woman full in the face. He was liable for not just what he did to the man, but the his malice, his mens rea also passed to another victim as well. So Rick is out on a date with Scarlett when they begin having an argument in the restaurant. Scarlett stands up and throws her drink in Rick's face, and I should say walks off. In this instance, what we've said before is, knowing what we know about the actus reus of battery, the application of unlawful force can be through an indirect act. Now, of course, Scarlett has not touched Rick herself, but her drink has. So an indirect act means that the case we really want to be thinking about here for the actus reus is the DPP and K, the acid in the hand dryer case, and that would illustrate the point nicely. Was this done intentionally or recklessly? Well, one would think that throwing a drink in his face was done intentionally because they're having an argument, and therefore, yes, a battery has taken place. So for assault and battery, these two offences don't result, remember, in the victim being injured. They are also common law offences. Now, as we move up, so figuratively, remind ourselves of that sort of pyramid of offences that we started with in terms of seriousness. When an injury is resulting from an assault or battery, then it will be charged under the statute, the Offences Against the Person Act 1861. So, which offence is committed, however, so we're going to look at section 47, actual bodily harm, ABH, next, but which offence it's charged with will depend on the severity, how serious that injury is, as well as obviously the mens rea. So, section 47, actual bodily harm, perfectly fine to call it ABH in the exam. Just be mindful as well the statute that it comes under that we described, and I would say again, in an exam, best practice, state the statute in full by its full name there, like I've done, Offence Against the Person Act 1861. But if you want to refer to it thereafter, I think abbreviating it as OAPA is perfectly fine. The actus reus for this offence is the D commits an assault and or battery that results in actual bodily harm. So as you can see from the photograph here, or the picture on the left, if you punch someone, then we know there is going to be an assault, because the person's going to see perhaps the your fist coming towards their face, so they're going to apprehend immediate fear of unlawful violence. When their fist then makes contact with your face, that's going to be the application of unlawful force, and if it's done with such force that it leaves a bruise, as you can see in the picture here, then we have actual bodily harm, and that's what makes it more serious because of an injury. Now, this offence of section 47 not only includes, for the first time here, physical injury, but it also includes psychological injury. So there will be a case, we'll deal with that shortly, but just be aware, physical and psychological injury apply to section 47. Now the mens rea is D, intentionally or recklessly commits an assault and or battery. So, it's essentially the same as what we've discussed before. As I said, now the only difference is the resulting injury. The sentence is increased. It is up to 5 years imprisonment that's possible. And I think off the top of my head, ABH, I think is a triable either way offence. Actually, no, it won't be, sorry. If it's up to 5 years imprisonment, magistrates don't have the jurisdiction or power to hear that case, to sentence it, to try it. So this would be, not a summary offence. It would be, I'm trying to think. I think it would be a triable either way. I have to check. Section 47 ABH key case then is Miller. And Miller is the defendant's wife had left him and petitioned for divorce. He raped her and she suffered from nervous shock. Now, why this case is useful for supporting the actus reus is it really outlined a test as to what is actual bodily harm. And actual bodily harm, I've paraphrased it a little bit here, simplified it. Actual bodily harm is any harm that interferes with the victim's health or comfort. So there's a whole broad range of things, potentially, that could be included. But if we just for the moment go to that picture we saw earlier with a bruise would obviously interfere with your health or comfort, therefore it's ABH. Funnily enough, I do remember an AQA exam question once where, if I remember correctly, someone had their face pushed down into I think it was something like a muddy puddle of water or something that was on the ground after a bit of a tussle, and the person swallowed some of the water when their sort of face was submerged in it, and as a result they suffered from, shortly thereafter, sickness, nausea, and I think a headache, and all of that, would meet the test we just outlined in Miller as well. So it would be actual bodily harm, even though you could say outwardly, physically, there was no indication of an injury. I did mention psychological harm, and this is our key case. So sometimes the examiner in a problem scenario will put this in, so do look out for it. Chan Fook is the case. The facts are, broadly speaking, a student who was lodging with the defendant was accused by him of stealing a ring, struck a few times, and locked in an upstairs room. So yeah, he was sort of hit about a few times. So if you don't give back this ring, you're going to get it, kind of thing. Having locked him in this upstairs room, he was fearful and panicking, and he tried to escape, but fell out the window and was injured. I think from memory, quite seriously. I think they suffered maybe it was a broken pelvis or other such things. But the argument and the point of law here is psychological harm. Now, the court ruled that actual bodily harm can be not just physical but psychological. So if you reach a state of fear and panic that sort of goes beyond, I suppose, mere emotion, as to make you psychologically disturbed, and that really is, for an exam purpose, just a point to discuss. I'm sure the problem scenario might not well give you much to go on. Then you can talk about this. Sometimes they give indications, don't they? I think in exam scenarios, things like, somebody having been assaulted doesn't want to leave their house. That could be an indication, certainly, couldn't it, of psychological harm. I think in the case of Chan Fook, the defendant was unsuccessful in proving this for their own case, but as I said, for the ratio, the court accepted that psychological harm would be sufficient if proven with evidence. So, if I cut your hair with a pair of my scissors, will I be committing an offence? And, of course, helpfully, there's a case that answers this. So, again, whilst the case we're looking for the actus reus of ABH, I would, make that the Miller case and outline that test that we described about the defendant's, anything affects, the victim's health or comfort. If there were a scenario to pop up where somebody's hair is cut, then this is the case to go to. DPP and Smith Michael, facts are the defendant forced his ex-girlfriend onto the bed and cut her ponytail with a pair of scissors. The ratio, therefore, is, interestingly, the cutting of, and this is the key bit, a significant amount of hair is actual bodily harm. So it's, a ponytail, as you can see from the picture there, is a significant amount of hair. If someone said to me, if you just were to cut one little piece of hair, one follicle of hair, then frankly, no. But again, this is something to be discussed in an exam question. Key case this time for the mens rea of section 47. We've got the case of Savage. The defendant threw beer over another woman in a pub. The glass slipped from the defendant's hand, and the victim's hand was cut by that broken glass. The ratio is, as we've said before, section 47, it's the same as for assault and or battery, exactly the same. So, in a problem scenario, you would have to, when you've read it, if you see that there's some sort of injury that's occurred, be it physical, psychological, whatever, then your mind is obviously thinking, right, okay, say it's a bruise, like we've been discussing, that's section 47 ABH. You would then have to explain whether or not it was committed via an assault or a battery. And it's just being mindful to look out for if there's any application of unlawful force. Therefore, section 47, ABH, it's been committed by a battery. Now, some problem scenarios for this. Again, pause the video if you want to work through them. Annabelle is intoxicated and asleep at a party when a fellow partygoer and friend Jane decides to play a prank on her by shaving her eyebrows off. Is this going to be a section 40 offence committed by her friend Jane on the victim Annabelle? Now we know, as I said before, the actus reus of ABH can be committed through an assault or battery resulting in ABH. Clearly here there is application of unlawful force, as she's, however she's shaved the eyebrows off, be it a razor, I would imagine. So that would be useful perhaps also to raise, the fact that it's a battery and the ABH is the eyebrows. So the case we're looking for, I think we just discussed, didn't we, was the Smith-Michael case. Was this done intentionally or recklessly, this battery? Looks very much like intentionally because it was a prank. I think a significant amount of hair, are your eyebrows a significant amount of hair? I would argue they are, given that they're on your face and it's one of the first things that people will see. An argument begins between Aminda and Rosie, who is pushed in front of her in a queue. After a shoving match, Aminda punches Rosie in the face. Rosie suffers a headache for the next day or so. You may well remember what we said about this earlier, but here you've got a punch, so we know there's a battery, the application of unlawful force, but now we've got the situation there with the headache. We know from the Miller case it's any hurt or injury that interferes with the victim's health or comfort. A headache certainly would, and therefore we can say quite clearly ABH is present. Edward owes money to a loan shark and violent thug. Having not paid on time, they visit Edward with two other men and force their way into his house, threatening him. Edward locks himself in his upstairs bathroom, and as they start breaking the door down, in a frenzied panic, Edward jumps out of the window. but breaks his legs. Now, you've probably stepped ahead of me on this, and you're already thinking about the Chan-Fook case, that psychological harm can amount to ABH. And I think here, frenzied panic, the word frenzied perhaps indicates that, with medical evidence, that may well be the case. And it certainly, would interfere with his health or comfort, this psychological harm. Was this done intentionally or recklessly? They lock him in the upstairs bathroom and they start breaking. Well, I think you could say that at the very least it's been done recklessly. Whether or not they'd argue, well, look, we wouldn't have thrown him out the window. But I think that they realised the risk, the defence who were breaking down the door, of what reaction might follow. And actually, you could, if you wanted to, I suppose, there's a causation issue. Do you remember from our previous substantive topic when we talked about causation, we said about, the victim's own act, or otherwise known as like the daftness test. And I think that, is it reasonably foreseeable to the defendants here breaking down the door that Edward would react in such a way, trying to escape? I think not. I think a court would accept that in that threatening situation, that was reasonable behaviour and was reasonably foreseeable, should have been, to the defendants. So I don't see that it being a break in the chain of causation. So Chan-Fook is the key case that I put there, but in terms of that causation issue, if you want to raise it, that would have been, if you remember the case of Roberts, and the defendant who picked up a young girl and refused to drop her off where she wanted, and the girl then was fearful of sexual assault from his behaviour and jumped out of a moving vehicle, suffering injury. Courts held in that case of Roberts that, it wasn't a break in the chain. Now, we've only got two offences left. We're obviously increasing in terms of the level of seriousness, and so Section 20, malicious wounding or inflicting GBH. Now, this actus reus of this offence is essentially identical to the more serious Section 18, but there is that use of the word, as you can see, inflict. Again, this is found under Section 20 of the Offence Against the Person Act, 1861, and the actus reus is D causes wounding or inflicts GBH. Now, to be honest with you, causes, inflicts, there isn't a great deal of difference to my mind as to the words, but I would always recommend try and keep to the word inflict for Section 20 if you can, but practically there seems to be little difference. This can include psychiatric injury, so once again we're seeing not just physical harm but psychiatric, and the mens rea is D intentionally or recklessly causes some harm to the victim. One of the biggest mistakes that can be seen with students' answers in the exam to questions involving non-fatal offences, particularly Section 20, is that they get the mens rea wrong. Be very, very careful. The mens rea is intentionally or recklessly causing some harm. Any other wording will not do. So the sentence, interestingly for this one, despite how, it says up to 5 years imprisonment, despite being the more serious offence, Section 20, because we have a wound, we'll talk about that in a minute, and GBH, grievous bodily harm, serious harm, it shares the same sentence as the previous one we just talked about, Section 47, which is clearly a lesser, a less serious offence. So there's a bit of discrepancy there. Section 18, we're going to deal with this one next, because the cases we're going to talk about for 20 and 18 are essentially shared. So Section 18, wounding or causing GBH with intent, so this being the most serious, this being a specific intent offence, again found under that Offences Against the Person Act. The actus reus is D causes wounding or GBH. This can include psychiatric injury. The mens rea, therefore, then is D, intends to cause GBH. The sentence, however, this one is discretionary life sentence. So this clearly is an indictable offence, the most serious that there can be, and would be dealt with, not in a magistrate's court, they don't have the jurisdiction, would be dealt with in a Crown Court. Section 20 and Section 18 then. The key case, first of all, we want to touch on is in respect of the wounding part. So for Section 18 and 20, if the result due to the defendant's act is a wound, then it's a point I'm trying to make. If the defendant's act is a result of the wound, then this is the case that we need to use. So the defendant fired an air pistol at the victim, where a pellet hit them near the eye, causing a ruptured blood vessel. And this outlined what a wound is for us. A wound is a break in the whole continuity of the skin. So in this case, with the pellet lodging in the side of the eye and rupturing that blood vessel, the victim was unsuccessful in this case in meeting the standard of what a wound is. So I think presumably it was dealt with under Section 47. But when we look at problem scenarios, a wound, the examiner's more or less going to give it away. They might use the word like, cut. That would indicate a wound. Anything perhaps in terms of bleeding or blood loss. So, that would kind of give you some sort of clues. What does grievous bodily harm, GBH, mean in plain English? Well, you should know that now. We have been referring to it, and of course it's not. Is it General Grievous from Star Wars? No, of course not. It is a useful case here. Again, sharing Section 20 and Section 18. DPP, Director of Public Prosecutions, and Smith. Defendant tried to drive off with stolen goods, and the victim, in this case a police officer, jumped on top of the bonnet trying to stop them, but was thrown from the vehicle and killed. And the court at the time said that GBH means really serious harm. Truth is, I think, since the case of Saunders a little later on, that the courts have sort of disposed of the word really, and it's just now left for us to understand it as serious harm. Section 20, Section 18, another shared case for actus reus is the case of Bollum. Do look out for this. The defendant inflicted bruises on his partner's 17-month-old child. What's the ratio then? Well, depending on the age and indeed the vulnerability of the victim, what might be a relatively trivial or lesser offence, a lesser injury for somebody, could be certainly a lot more serious. So to paint this clearly, if someone were to punch you and you, as a result, suffered a bruise, then we know that would be ABH, actual bodily harm through a battery. If, however, for example, a small child or somebody in their 90s were to be punched, then that would be a more serious injury because of their vulnerability, and therefore the prosecution, CPS, would charge that to a higher degree, and it would constitute grievous bodily harm, really serious harm. We talked about briefly biological disease earlier, and this is the case to raise. Again, it's one of those cases where you just only want to raise it if it's relevant to the scenario. So if it doesn't have any indication of biological disease, then don't talk about it. And the case of, again, is it Dicker, is it Dicer? I'm going to say Dicker. In the case of this, defendant was diagnosed as HIV positive. Knowing this, had unprotected sex with 2 women and gave them the virus. And courts held here that, biological disease, namely HIV, which could lead to full-blown AIDS, although thankfully by today's standards, medical advancements means it's not quite perhaps the death sentence that it seemed to be, but nonetheless it's still serious, can amount to grievous bodily harm. And although we don't deal with the defence of consent, generally speaking, certainly on the AQA exam spec, which is a shame because I used to like teaching consent as a defence, but clearly, you can't consent to as a serious injury. The law will not permit that. There are exceptions, of course, which could be, for example, the need for medical or surgical treatment, but clearly this is not one of those situations. What have we got now? The case of Burstow. Case of Burstow, again, the victim ended a relationship with the defendant who could not accept it and then began a campaign of harassment. Subsequently, the victim suffered from a severe depressive illness. So this case is the kind of mirroring case from Chan Fook that we did for ABH. It's recognizing that psychiatric harm can amount to GBH. So again, in a problem scenario, for example, I did give the example earlier of how somebody having suffered, say, an assault of some description, doesn't feel able to leave their home. Now, it could well be in the the problem scenario says something like, they wouldn't be able to leave their home for months. And so there would be an indication through the wording that whatever psychiatric illness they're suffering from is severe. Case of Parmenter is the case we would like to use for supporting the mens rea, but this is just for Section 20, remember, because Section 20's mens rea is different from Section 18. And Parmenter, we have the defendant handled his baby roughly, which causes injuries to its legs and forearms. The ratio is, as we said before, Section 20 is a basic intent offence where it's sufficient for the defendant to have intentionally or recklessly caused some harm. And I guess in this scenario, I can't remember if this is the one, where he was throwing his baby up in the air and trying to catch it, just a bit rough, which you shouldn't do. So one could say that he was certainly reckless, realising the risk that some harm could occur. And some harm is quite a sort of a broad sort of spectrum here. It's interesting to note the defendant doesn't have to foresee the specific type of harm. Just some harm is enough for Section 20 if the result is a wound or GBH. Now, this is actually, I'm going to say this is actually an error on the slide here. This should say Section 18, not Section 20, so apologies. It should say Section 18 because this is the key case for Section 18's mens rea. Taylor. Defendant was found with scratches on his face and a stab wound in his back. Therefore, the ratio for 18 is that an intent to wound is not enough. There must be a specific intent to cause GBH. Now, just to explain briefly, we know that essentially the actus reus, the guilty act of Section 20 and Section 18, are identical. So that was essentially wounding or GBH. The mens rea of Section 18 is the more serious, we've said, because it can only be committed intentionally. And it makes clear here that that intent has to be from the defendant to cause serious harm, not a wound. If, however, the result is a wound, they're going to be charged under Section 18 if that was their intent to cause serious harm. And as you can see here, stab wound in the back would, I think, certainly meet that. So yeah, again, that's just really what I talked about. If the actus reus is the same for Section 20 and 18, did you spot the difference? What makes 18 more serious? It's all about the mens rea. In the news again, Justin Lloyd, 22, approached a woman, the woman there on the left that you can see, and her friends on a night out back in 2014. Apparently he offered her a crisp. When she refused, he poured the packet of crisps over her head. one of her friends, I beg your pardon, one of the friends, so that's the person on the left, one of her friends, Shadia Omar, so there's Shadia Omar on the left, 22, came to the aid of her friend who had this packet of crisps poured over her head by taking off her designer shoe with an extremely long stiletto heel and then striking him in the face. And sorry for those who may be a bit squeamish, but the stiletto entered the corner of his eye and caused a serious injury. Now, miraculously, the victim, Justin Lloyd, didn't lose his sight, but he claims he was left with pain in the eye and also the psychological effects, be that sort of anxiety or PTSD or whatever. And interestingly, Shadia Omar pleaded guilty and received an 18-month suspended prison sentence. So this is a good example, just seeing in the news, of perhaps psychiatric injury as well as other things. Now, scenarios for section 20 or 18, which is it that's going to be relevant? Again, pause the video if you want to go through these. We're going to do that now. Josh throws his baby up in the air and catches them while playing. However, it leaves a bruise on the baby. So this is really, first of all, the bruise is the injury, but we're dealing with a baby. The baby is a more vulnerable victim. So we're thinking of the case, aren't we, called Bollum. And therefore, it's possible that, we know a bruise is usually ABH, don't we? But with a vulnerable person, it would be more likely dealt with under section 20 and considered to be grievous bodily harm, serious harm. And again, it's similar to that Parmenter case, isn't it? While Aria is out walking a dog, she is confronted by a mugger. They slash Aria with a Stanley knife and run off with her mobile phone and credit card. So here, I'm looking to the injury. It says they slash Aria with a Stanley knife. So it doesn't give us too much more to go on. Probably going to be a wound. It's safe to say. Has that been done, intentionally or recklessly to cause some harm, or is there a specific intent to cause GBH? Remember, of course, certainly for the CPS and prosecution, it's going to be always easier to prove section 20 than it is section 18 because of that specific intent part of the mens rea. So I think for Aria, we can say there may be an argument for section 18 there, wounding with intent. The intent, therefore, is to cause a serious harm in order to steal. There is a break in the continuity of the skin, so there is a wound there, in other words. But if you went section 20, I don't think you would be wrong either. Now, this is an important point. In the AQA exam, problem scenario, if you're presented with something like this, where it could be section 20 or section 18, then, a really good answer, and for those expecting and wanting a high grade, a really good answer will always discuss both possibilities. They will always discuss both offences together before reaching a conclusion. Because, of course, section 20 and section 18 have the same actus reus effectively. It's only the mens rea that's different. So you should approach it really by explaining both, and then give your view as to why you think it's one or the other. And there's usually a bit of flexibility in the exam on this. Nancy is in a sexual relationship with her partner Jack. On one occasion, they don't use protection. Unknown to Nancy, Jack has recently tested positive for HIV from a previous relationship and is hiding it from her. I've also put, would your answer be different if Nancy knew and consented to sex? Now, of course, your mind should be thinking about the Dicker case, about biological disease that can amount to GBH. Whether or not then it's going to be a matter of, is it section 20 or 18, depends on the mens rea. Has he, intentionally infected her to cause her GBH? Or has he simply been, maybe you could say he's been reckless in this instance? That would make it section 20. Either way, for you to decide and argue. And if she consented, well, in law, you, as I said before, you cannot consent to GBH, so it would be irrelevant even if Nancy knew about it. So I put here, yes, it's present for section 20. I felt it was more a recklessness, perhaps, argument in that instance. In the news again, just an example of biological injury. Darryl Rowe, 27, using the dating app Grindr to meet 8 men in Brighton, and this was during a 6-week period in 2015. He didn't tell any of the men that he was in fact HIV positive. He set out to intentionally infect as many men as possible having unprotected sex, and then essentially trying to ridicule the men afterwards. And unfortunately as well, we don't know quite exactly how many men he may have infected, because not all have come forward for one reason or the other. But horrible sort of person. One you can see there, one of the victims was driven to suicide, and quite clearly this is a section 18, given a life imprisonment, a life sentence, to serve a minimum tariff of 12 years. So remember, with a life sentence, the judge has given it. He'll serve a minimum of 12 years, and then when he's released, he'll be released on license as soon as, I guess the parole board are as confident as they can be with evidence that he will no longer pose a risk to the public, but he will be monitored and on license for the rest of his life. So this might be useful to you, I think, when you're revising, because of all, if you look at past exam questions, say for AQA, the types of injuries and such that could occur. So I've got from everything from a bruise, a scratch, all the way down to what we discussed about psychiatric and psychological injury. And I think just trying to match it up to the relevant offence so that you're confident in the exam that you know which one you should be talking about. Analysis and evaluation of non-fatal offences. So this is our assessment objective 3. Remembering, of course, again, that this is an objective that is present in all problem scenarios. So, the 10-mark problem scenario will have a degree of AO3. Largely, as I said before, for the 15 marker, this sort of thing to talk about. And then, of course, with the larger problem scenarios for 30 marks. You have an element of AO3 as well. Now, just briefly, picked up on a few things. I mean, your analysis, again, is you discussing the cases and why they're relevant and so on. But if you're wanting some evaluation, we can say the word assault, in everyday language, really means, to most people, a physical attack. But we know from the case law that an assault someone can be guilty of, even if they haven't touched the sort of the victim, because assault doesn't require any unlawful contact whatsoever. So it's interesting in that respect, the language. Whether you say that's fairly labelled is another argument as well. The sentence for section 47 and section 20 we briefly mentioned. Despite section 20 being more serious than section 47, because 20 deals with wounding and GBH, both reflect 5 years imprisonment. Now, this goes against something known as the correspondence rule. You might be asked this in your 15 marks question. The correspondence rule, this is where the defendant must intend or foresee the result, that actus reus. However, if the defendant is liable for section 20, if they intentionally or recklessly cause some harm, but they don't, as I said earlier, need to intend or foresee exactly what this is. It just says some harm, like the father throwing his child up in the air to catch. Perhaps didn't, specifically foresee that would result in bruising that could amount to, for a vulnerable person, being a baby, section 20. So is it fair to hold, the defendant at fault when they can't specifically foresee that type of harm? So that's really something the correspondence rule talks about there. Outdated language, I mean, this is from 1861, this statute dealing with section 47, section 20 and section 18. And so, when we talk about GBH, it uses the word grievous. How many people use the word grievous these days? Very, very few, I'm sure, in everyday language. And so in plain English, it means really serious harm or serious harm. Also, the word malicious. Malicious in everyday language, you would think, intending to do harm to someone, deliberately, evil. But interestingly, where malicious is mentioned in section 20, malicious wounding, the mens rea is intention or recklessness. So the language is, again, quite sort of outdated in that regard. And that, I think, is as far as I'm more or less going to go at the moment, because I can't show any AQA exam questions, obviously. But I will maybe just briefly say that there are some useful mnemonics, some useful sort of ways in which you can structure your answers to problem questions, one of which I've already talked about on my channel, called IDEA. So do please check it out, and I'm simply going to say thanks very much for listening, and good luck with your revision.